Hello, everybody, and thank you again for joining us for today's webinar, Tips from the Trenches, Practical Considerations and Best Practices for Remote Arbitrations. Today, we intend to cover practical tips from members of the litigation spectrum that include prominent lawyers, litigation consultants, and some trial technicians who have firsthand experience with taking cases through a remote arbitration. Through this program, we hope you gain a better understanding of how to prepare, what to expect during a remote arbitration, and how to navigate these important proceedings for you and your client successfully with minimal surprises. Our panelists today include Vincent Camacho, a partner at Milber, Macris, Placidis, and Seiden, LLP, Jeff Eberhard, a partner at Gare, Eberhard, Nelson, Dedinas, Ltd, Dr. Ann Greeley of Decision Quest, Greg Casson, the National Director of Trial Technology with Decision Quest, and I'm Jeff Cohen, Director of Business Development here at EWIS Legal Support. Now, during this presentation, if you have any questions for our panel, please feel free to submit them via the chat feature on your screen, and we will do our best to answer those towards the end of the presentation, time permitting, of course. With all of that said, let's go ahead and jump right in with our first topic in question. So Greg, I want to start things off with you. As practitioners and technicians who have conducted remote arbitrations, I want to first discuss how can an arbitration even take place in a remote environment?
So they're very similar to the way remote depositions work. All parties receive a link, password protected link, that they can connect into the remote platform, and they can view each other, view the witness, view the exhibits, and also get real-time recording feed as well. And that is every party, the witnesses, the attorneys, and the arbitrator all have that same link.
So if all of these services you just described are available in an in-person setting, why would a firm ever need to even have the consideration of taking an arbitration remotely?
Yeah, well, in the instance of our case, we were scheduled for a week-long arbitration to commence on March 30th, 2020. And that became apparent about 2 weeks before the hearing that was not going to happen. And so what we did is we, opposing counsel and our side agreed to, to try to delay it a few months and see where we were. And everyone had a strong preference for an in-person hearing in the beginning. And so we rescheduled it first until July 2020. Then that became apparent that would not be possible as well. So we continued the hearing to September 2020, and sometime in August, again, we realized that wasn't going to happen. And so what we decided to do was to set the hearing, to reset the hearing until January 2021 at that point. And we were hopeful that we could still do an in-person hearing, but one way or the other, we decided either we'd do an in-person hearing in January or we would do it remotely. And obviously we did it remotely and it worked out great.
Another thought too, I'm sure that your clients and other lawyers involved in these cases don't necessarily want to wait for the ability to hold an in-person arbitration, so remote could potentially be the only option that you face there.
Yeah, so that actually happened in my case. We initially were scheduled for the spring of 2020, and actually for reasons not related to COVID, it was pushed to the fall of 2020, September 2020. But over the summer, the opposing counsel in our case was really pushing to continue to push for in-person arbitration. However, our client, had this litigation having gone on for years, was really wanted to have the arbitration commence, and we ultimately pushed to have them virtual, and the panel agreed, and ultimately we held 21 hearing days from September 2020 to through December of 2020.
That's awesome.
Yeah, it went really smoothly.
You mentioned that the parties were pushing to have the physical hearing. Do parties have a right to a physical hearing as opposed to proceeding remotely?
Well, actually, the parties often will agree to the rules of the arbitration based on whatever organization they've joined in with, perhaps AAA or an international arbitration organization will lay out some of those rules, and they are often by the parties' agreement. But there's some literature now that's suggesting that the arbitrators actually can force a remote arbitration, at least in these times, we don't know what's going to happen down the road, but at least now they sometimes do have the ability to force a remote arbitration in lieu of an in-person arbitration.
Right, and I also, people have to remember that when you're entering an arbitration, you're agreeing to specific rules and, beforehand. And today, that's something that you'll agree to, whether or not the arbitration will be remote, in person, whether or not the choice will be the party's choice or the arbitrators will have the decision. It all depends on what the parties agree to prior to entering the arbitration.
Mm-hmm.
And building on that point, with remote arbitrations, you won't really run into a circumstance where the proceedings need to be canceled due to a health and safety precaution implemented by local officials. And with everything changing with COVID so quickly, we regularly see offices get opened up and shut down less than a month later. So that's something that can be removed from that. Also, weather issues like what happened in Texas and Mississippi earlier in the year, those won't cause any delays earlier or either. So I guess on that line of thinking, Greg, can you think of any other benefits of a remote arbitration that you personally experienced?
One of the things we have noticed, and just from an observational standpoint as a tech, and it's not tech related, but more folks are able to participate. Paralegals, the assistants within your office or from home can much more easily participate, along with second and third chairs and corporate counsel, by not being limited geographically, is one of the small things we've noticed, but it can make a big impact to have that team close to you.
Yeah, it had a big impact in my arbitration. The one, the witnesses aren't necessarily in the same state, or even in my case, the same country. My client was actually in Toronto, Canada, and during September 2020, you couldn't get into the United States, so there was no way that they could be even in my office. So a virtual arbitration was the best solution for that. We were able to prep and we were able to have them appear. Also, one of our main experts was in San Francisco, so we avoided having to have this expert fly over to New York. And as anyone knows, in these proceedings, you don't necessarily know which specific day you might be going, so it's difficult to get plane tickets and things like that. Scheduling can be an issue. It actually, I believe, made it really convenient to be able to just tell my expert, okay, you're going to be definitely going this day, or be prepared to go this day and this day, and then your prep is better, and it went a lot smoother during the actual arbitration and the test, and for that expert's testimony.
Yeah, and from my perspective, the flip side of that coin is, in my hearing, we were the respondent, and we had planned to call two third-party witnesses, one who lived in Florida and the other who lived in Ohio. So they both would have had to have flown into Chicago and been prepared to testify. But in this case, in the very last minute, literally right before they were scheduled to go on, we decided not to call them because, based on how the evidence had come in, we didn't think we needed them. And there were things with the witnesses that, we were a little worried about. And so we were able to say at the last minute, hey, we're not calling these guys. And had they flown in, I get the sense that we probably would have called them because they would have, incurred the expense and we would have prepped them and they'd be sitting there waiting. But with the flexibility of a virtual hearing, we were able to make last minute calls like that. And the other benefit that I noticed from having a virtual hearing had to do with showing witnesses documents. I think doing so by screen share, it really kind of cuts down on some of the time and process. Typically when you're in a big conference room with someone and you hand out a 20-page document, certainly the lawyers and the well-coached witnesses are going to take a lot of time to flip through every page and familiarize themselves with the document. But with screen share, I was able to kind of take control, put the document up, direct the witness's attention to page 7, highlight it, and go ahead and ask my questions. And in that format, I just found that things went more smoothly. There was less kind of game playing with, oh, hold on, I got to look at everything and understand your question in context. And I was able to kind of get my Q&A out in a more streamlined fashion.
Yeah, another benefit was also, that I failed to mention, was just the home field advantage. You're in your own office, you have access to your own staff, you have access to your own document repositories. If you're second chairing, you have easy access to substantive information, and you can, particularly on cross-examination, if you know your documents really well, as you should going into arbitration, you can bring up evidence for cross-examination testimony on the fly. You don't have to worry, did I bring that particular binder with me? Do I have the right hard drive? There's a lot of guessing that is removed from actually being in person and not being in your office.
Those are some really interesting points, and probably some things that many people don't consider as they're preparing. And then, as the likelihood of more remote arbitration continues to grow, I'd assume there is some significant preparation that's going to be required by the party. That really brings us into our next topic. It's going to be the preparation for these remote arbitrations themselves. I'm going to go back to you again here, Greg. For the first step in the process, what would you consider the most important thing the firms need to address?
And so to start, it's a combined thing of two here. It's if you talk to your vendors like us and the arbitration organization or association that you're working with, you want to find out one of two things. The first being who's going to host the arbitration from a technical perspective. Once that's determined, whether it's a vendor like us or the arbitration organization themselves, you want to find out what platform will be used, whether it be Zoom or the other platforms out there. They have different capabilities. One that comes to mind is recording. In some of these arbitrations, the two that Jeff and Vincent were on were not recorded, but some are recorded. And if they're being recorded, how does that look? Do they have time and date stamp if you need time and date stamp? That's one little thing there. But all of them have different layouts, video layouts, dual monitor mode, and things like that you want to consider. And then along with, again, who will be hosting that.
So it sounds like obviously that's a really important factor, is just establishing your platform itself. Once you've identified the platform, Greg, what would really be the next step for you there?
The first one will be where will everyone be? So it's a combination of where will everyone be and how will we set up equipment, or you set up equipment for that situation. And you can participate remotely from your homes or social distancing within your office in groups, or a combination of both. Once that's decided, you may want to order second monitors, work off of big TVs in the conference rooms, set up virtual counsel tables in a way, and virtual witness stands in a way. And so you may need, like I said, that equipment. You want to work out the audio to make sure there aren't any echoes, and you're not using multiple sources. We suggest not using tablets. You do want something sufficient to see the documents. And then lastly, you'll want to consider what equipment the arbitrator has at this point as well. And maybe we send a monitor to the arbitrator to make sure they have dual monitors, or if they prefer the laptop, we can work with that as well.
So it sounds like there's really a lot of different setups that you could potentially have that have some pros and cons to each. Is it a requirement that all parties participating have an identical setup?
No, absolutely not. It's all down to preference. Some folks are great with a laptop with just side-by-side mode where you split the screen in half. Some folks like dual monitors. Some like built-in systems in their office where they are running like a Polycom type of video conference system.
So I guess my next question is going to be geared more towards Vince and Jeff. I'd love to hear a bit more of maybe your secrets of how you prepared for your remote arbitration process, whether it involves the platform itself, some of the equipment Greg was just mentioning, or any other things that you found personally important. Jeff, I'll start with you if that's okay, just about your preparation process.
Yeah, sure. In terms of witness prep, I'm in Chicago, and our client and principal witnesses were located outside of Madison, Wisconsin. And so we did all the preparation via Zoom. We had multiple prep sessions set up with Zoom. We got used to, I sent them binders of exhibits, but I also went through the screen share process with them and prepared the witnesses that way. And you know, that helped kind of get everyone comfortable with the process, and it also kind of helped work out some kinks in terms of, you know, if I had someone leaning too close or sitting too far away, we could go through some of that. You know, in contrast, our opponents, didn't appear to have done that kind of prep with their witnesses, and it showed. In one instance, they had a third-party witness who they hadn't done a dry run with, and he couldn't get his video working on Zoom because he was at work using his work laptop, and they had, I think, put a piece of black tape over his camera, as some companies will do, or somehow disabled his video, and so
Simple fix.
yeah, he couldn't appear on screen and had to end up just doing audio only, which, as you can imagine, it didn't have much of an impact.
Right. If I could jump in here, I know that's really an important thing I think that you did with regard to your witnesses, making sure that you had prepped them in the situation in which they were going to find themselves. I mean, that is really pretty key in terms of getting people comfortable. We do a lot of also remote witness prep with people before these kinds of hearings, and it is almost always remote, but it's also important you added the dimension of, you know, the screen share, et cetera, that I think is really an important component that you can add. I know that one of the things we try to work with is the audience. You're thinking about the audience the whole time. You're thinking about, who am I going to be presenting to? And arbitrators really aren't that different than other people, and human beings, of course, and really different than jurors in that sense. And I know other arbitrators have told us that it's important that you think about them as learning this information, sometimes for the first time, depends on the level of experience. They are very intelligent people, but they also have things like Zoom fatigue. They have cognitive overload. They have the kinds of things that really, in this type of setting, with the remote setting, you're talking about needing to deal with an extra layer of concern to make sure that it's as vivid a presentation for them as possible. And it also underlines the making it simple, and it underlines the fact that you've also got to make sure that your briefs, these things are unique in that they have more briefs and submissions ahead of time, or at least an equal number to trials, right? I mean, and then judges rely on them a lot. So making those simple and, cutting to the chase on those, and making sure your witnesses are answering, well, why is this important? Why does the judge need to know this, or the arbitrator need to know this at that point is also really important with your witnesses. Think about that audience.
Yeah, I agree. I think testing testing the system with your witness is one of the most important parts, probably next to substantive prep. Because how the witness presents is key to any arbitration or fact-finding proceeding. And if you've tested with your witness, and generally you want to test while you're prepping the witness substantively, it will make for a much more relaxing presentation of that witness's testimony. As far as technology is considered, don't overdo it. I think this was touched on a little bit prior, but we had a very simple setup. We had 2 monitors with 1 camera, and that way it looked like we were looking at the witness when we were speaking with the witness. You can actually pin the witnesses or who's the speaker's screen up so everyone can see who's speaking. You'll avoid those awkward moments where you're talking but you're looking at something else, or if you have, our opposition had these giant screens in their office, and it got awkward sometimes because they would actually walk up to the big screen to look at something that was small instead of if they had it right there in front of them. You want to make sure it's, that your theme doesn't get lost in, what's going on technology wise.
And one of the things we've been getting are calls for 27-inch monitors or 30-inch monitors, as Vince mentioned, and you don't need that for the situation. If you have a 15-inch monitor, if you have a 20-inch monitor, that'll do just great. You also don't even need that. Again, 1 laptop split in side-by-side mode will work well. The other thing we mentioned a bit ago is the Polycom systems. If you have one and you like to use it, great, but these arbitrations go extremely smoothly with either just a laptop or a laptop and a second monitor.
Yeah,
and also,
I would definitely agree. My partner and I were the only 2 humans who were together for this hearing, and we both sat in our large conference room. And the setup we had is we had 1 computer for the attorney who was presenting. So we used the audio from that computer and then muted the second computer. But we each were using our laptops, and then each of us had a second screen for the documents. And by the end, I kind of stopped doing that because for a couple of reasons. One is there were times where the witness would be up on the second screen, so the attorney would be looking at the witness on the screen, which made it look to everyone else that they weren't looking at the camera. So it kind of created this awkward situation. And then, trying to toggle back and forth on two screens, and sometimes you get them mixed up, which is the right and left monitor, and that was user error, not anything wrong with the setup. But by the end, I kind of disregarded that, and I would definitely agree that just a simple laptop and split screen is fine.
And you also mentioned a couple of times about just really understanding the platform and understanding the benefits of it. Speaking of, the platform we're working on today is great for hosting webinars. This is not something that we would then suggest to use for hosting an arbitration. There's some, echo that occurs, some other things like that. So when we host arbitrations on a platform, we wouldn't use something like this, and that's something that we'd find out through the testing with the law firms and also with your clients. You also made a couple of great points about the dual monitors. I always notice if I'm communicating with somebody, and I personally have a second monitor on the right, if every time I'm talking to you guys, looking at documents here, the personal communication during the actual proceedings doesn't feel the same. So kind of leading that into our next question, do you have to make sure that the arbitrator is up to speed on all this technology and have them participate in any kind of practice sessions?
Yeah, in our case, we didn't. We told them shortly before the hearing that we had agreed on a protocol for handling it remotely, and we offered the opportunity for them to practice and do a dry run, and they didn't take us up on it. And in fact, each of our 3 panel members had done several virtual arbitration hearings already, and they were more adept at it than we were, and much more comfortable with it in the beginning. So it was very seamless.
Yeah, so I had a 3-panel arbitration. However, it was September 2020, and I don't believe at that time any of them had done a remote arbitration, and you couldn't expect at that time that people would be comfortable with or experienced in remote arbitrations. But I have to say that Greg did a very good job of getting them up to speed and keeping them up to speed. We did a lot of practice with the panel, with putting up documents and things like that. We had a joint repository that was massive. So, so we had to, early on lay down the rules on how that repository we managed. And, we had 2 very good techs, John and Eric, who were able to pull up documents throughout the arbitration panel. We really had to make sure that early on that everyone was comfortable, and also testing with your witnesses individually was also crucial.
You mentioned establishing some rules when it came to the repository of documents. It makes me wonder, do you also typically have any conversations regarding just the overall ground rules of the remote setting as a whole?
So for Vince's arbitration and a lot of the arbitrations we've done with arbitrators that haven't been in this remote setting before, we do have a meeting prior to the arbitration, the Thursday or Friday before the start date, and we go over the tech things that deal with procedural matters that are preferences of the arbitrators. One of them is ex parte matters, or ex parte discussions, and how we're going to handling that through waiting rooms. How are we going to deal with witnesses that pop in midday, and do we want to put them in the waiting rooms, or if there are side by side in the waiting rooms? So that, and who's going to stay on camera, who's going to stay off camera, things like that are discussed beforehand, and it's all to the preference of the arbitrator.
The rules for how exhibits would be called out were laid down in advance of our proceeding. It was that was a real important part of the arbitration.
Vince, it sounds like you're having a little bit of audio funk there. Just wanted to give you a heads up on it, but continuing on, no problem for there. I guess kind of that exact topic, as you continue these conversations and you identify the skill sets of everybody, I'm sure you kind of identify that there's some folks who have a very high level understanding of the technology, and then there's maybe some folks on the opposing side that have a lower level, less tech savvy background. how can you really assist those non-tech savvy individuals? And Greg, that's probably going to be a question I direct to you.
Yeah, so practicing and practicing early and practicing until the kinks are worked out well before the arbitration, if it's a week or two before, and then leading up to it. So we have time to fix the issues before the arbitration starts. We have been working with attorneys and witnesses and arbitrators of all tech skill levels, and we work with them in a way that they understand whether they're super tech savvy or not. We can walk them through remotely all these different things. And it really is a collaborative effort to make sure everyone has all those issues worked out, which there will be some, or technical training done before the arbitration, so that one person doesn't cause the whole arbitration to go off track with a tech issue. And it's all about preparation.
Yeah, and I guess from my perspective, there's going to be issues. We had a couple panel members who were at home, and there were times where they got dropped, and luckily we usually noticed within a couple seconds and got them back on right away. And we had a couple visits from some dogs and things like that, but it wasn't a big deal. And I think it's one of the benefits of arbitration generally that you're in a professional setting with people who do this for a living. So you have to be somewhat flexible, but I didn't find it disruptive at all.
I agree. You have to be flexible. Things are going to happen. We had an arbitrator completely, his computer shut down, or he got a notification that his computer was going to shut down in 5 minutes during pretty crucial testimony. And honestly, it lightened the mood when it happened, because it was kind of a comical situation that was completely out of anyone's hands. So it's just roll with the punches. Like Jeff said, the dog barks, lights go off, internet failures, it happens. You'll be back up. Restart the testimony. You'll get your record. You'll be fine.
Vince, if I could actually jump in, speaking of technical issues, again, it sounds like a little bit of funk with your audio there. If it's possible that you could dial in as opposed to using your computer audio, we'll just continue the conversation on. I just want to make sure. And that really goes to the point we're talking about right now is, regardless of how much preparation you put into getting ready for these remote settings, whether it's a deposition, arbitration, or even a trial, technology issues do arise. And the key with the training and the preparation that we're really talking about is understanding that it should not derail the entire experience for everyone, but it should give you at least some understanding of how to potentially work around the issues and keep the process flowing. And kind of with that exact sentiment in mind, we'll continue with some of these conversations here. And I guess my next question is then for Jeff, as Vince gets his audio back in place. During this preparation process, and I know we briefly touched on it, but I think it's important to really hone in on it a bit. What types of conversations are being had revolving around the actual exhibit preparation and methodologies being used during an arbitration?
Yeah, so I think this is an issue that is important for every arbitration. There's going to be people who prefer hard copy exhibits, and there's going to be others who look at a screen. And every in-person arbitration I've done, there's always a mismatch there where I'm standing up pointing at a screen, and I look over at the arbitrator and his head's buried in a binder, and I kind of feel stupid for standing up by the screen. And so you always have to feel that out in any arbitration, whether it's in person or virtual. And for our virtual hearing, we had the same thing. We had one analyst who said, please send me hard copy binders. And luckily in our case, it wasn't terribly document intensive. Each side had one binder of exhibits. There were a couple of very long spreadsheets that we couldn't print out that had to be put up on the screen and done electronically. And then we had another panelist who said, please don't send me hard copies. I'll never look at them. I only want to look up at the screen. And so, to me, doing it virtually didn't add on any layer of complexity that didn't already exist in the arbitration setting when you have different people with different preferences. So again, with the screen share, what we did is we had one Zoom host who was both acting as the Zoom host, meaning putting witnesses in the waiting room when they showed up, and then putting the respective sides into breakout rooms during breaks. And that same person was also kind of the hot seat operator. So they had all the exhibits preloaded the trial director. And so both sides, just anytime they wanted to put up an exhibit, would just, say, hey, Jim, put up exhibit 3, and they would. And there was times where, for one reason or another, one of the attorneys kind of took charge and did screen sharing from their end, but it was very easy.
That's good. And I'm hoping Vince's audio is working back in, because Vince, I know your arbitration was very document intensive. I'd love to hear a little bit about that process.
Yes, can you hear me fine?
That's perfect. Great. Thank you.
This is part of it, right? We were just talking about technical issues that can happen. No, it was a very document intensive. We had about 3,000 to 4,000 exhibits that were exchanged before the arbitration. I initially thought I'd be, pulling up a exhibit and going to the page that I wanted a witness to focus on. But thankfully, we were using John and Eric from U.S. Legal Support to help. They were amazing. I would tell them, I would call out an exhibit number. I would say the PDF page to go to and which paragraph to reference. And all of a sudden that paragraph and that piece of evidence was blown up for everyone to see. It took away from the distraction of seeing a document, I think, and more focus on the witness, because you saw the evidence and then you could see what the witness, or hear what the witness was going to testify. The one thing, though, I would recommend is making sure that your repository of exhibits is well organized, because I think that was helpful. We worked with John and Eric to do that. They created spreadsheets with hyperlinks that could pull up exhibits. That was incredibly helpful. And I honestly, I think even if I'm going to do an in-person arbitration or if I'm back in the trial room, as trials in New York are starting to open back up this spring and this summer, I definitely, on a case that was similarly document intensive, having a tech there to help with the presentation of evidence is something that I will recommend to all my clients.
And I think you really raised a couple of great points with the exhibits, especially in a documented case like that. The more preparation you put in, the better things are going to run. It's just kind of the rule of thumb that we find in the remote setting. And business data grows, I think, at an exponential rate of almost 3 to 5 times a year right now. We're not going any further away from having more documents. So having a strong understanding of how to manage that information, especially with access in the remote environment, is really important. And I know, Anne, we haven't heard from you in a while, so I want to loop you back into this conversation and kind of talk a little bit about the aspect that people utilize jury consultants and mock trials historically as they prepare for their in-person trials. Would those same types of processes or those same types of offerings exist for a arbitration setting, either in person or in a remote setting?
Right. Oh, well, we absolutely have. We used to do and still do, well, we will do in-person arbitrations, but we've certainly done mock arbitrations online for a long time, and we've been able to do that, of course, with our jury studies. But we really tend to think of ourselves as communication consultants more than just jury consultants. So it's more of we study persuasion, we study the fact finder, and whoever the fact finder is, we focus in on what's going to be persuasive to them. And so one of the things we do is these online mock arbitrations, so that we have, and it makes it a lot easier, frankly, because sometimes we used to have judges flying in from California, as others have mentioned, flying in to do the mock to New York or to Philly or wherever. And now we're doing all of these things online. We're getting the same kinds of quality people, the judges that can participate. They're from agencies or organizations that do these things all the time, but now, and they love them because they want to do the mocks, because there isn't as much pressure as there is actually in a real, there's nothing binding about a mock arbitration. So it's kind of a great exercise for them. They get a chance to share their thoughts. One important part about that, I'll say, from using somebody who's a jury consultant or a trial consultant to do this, is that it's all done blind, so that nobody knows who is actually putting on the exercise. So it's important because you really get an unbiased view then of the case. So things are redacted. There's a lot of care taken in doing conflict checks, et cetera, so that makes sure that people are not necessarily biased. We're not trying to please anybody who's hiring them at that, which can happen. So I think one of the things that's most important that we've learned, though, is that you've got to get the right briefs in the hands of the mock arbitrators, as well as, you all know, at the hands of the arbitrators, because simplicity is everything, and we really got to work on keeping the theme simple and making sure that they're getting through that's one of the biggest things we've learned, and certainly you all have talked about. And sometimes we've been able to also test witnesses, which has been an important component of those, which obviously is important. Who's going to, how are they going to view your witness in that situation? So yeah, I think mock arbitrations are going to stay, actually, even if we get into in-person arbitrations again, for sure. The mocks, as far as the arbitrations are going to go, will stick remote.
Yeah, I think as we adapt to this new working environment, I wouldn't be surprised to see an uptick in the usage of those types of requests as we just try and understand our environment and how these cases proceed. And now, kind of summarizing this topic we've just discussed, we've really talked in depth a lot about preparation, and now I want to talk a bit about what it's going to actually feel like in your actual arbitration. I know we've talked a little bit about that, but the first question I guess I would ask for you is, during the actual proceedings, Vince, who is, and I guess also at the same time, who should be on the camera?
In reality, the person who should be on the camera is who's talking. So whether it's the witness, the attorney, or the arbitrator, I think I mentioned earlier that we can pin the person speaking so that that's the person who is being heard and focused on by, whether it's the fact finder or the witness if they have to hear it. I thought that was really helpful during the arbitration.
Now, Vince, sticking with here, and I guess there's some pretty solid relevance. What would you do if there's any audio or video issues happening, and how could you fix something like that in real time, I suppose?
Right. Well, we just, I guess serendipitously we had a tech issue right now, and that I can tell. I'll tell the little break the fourth wall a little bit. I got a text message from someone at US Legal to tell me how to call in and get that fixed. And here I'm back and being able to to speak clearly, and I can be heard. So that it's the technicians. That's where the technicians come in, and they make it run smoothly. Things are going to happen. You got to relax, roll with it, and keep moving.
And so to add to that, our hosts, myself and other hosts at our company, what we do is sit on there throughout the arbitration. After all the preparation that we talked about, we're sitting on throughout the arbitration and making sure everybody gets into the room and doing all the monitoring of the room and the security. But also, we are the tech lifeline. So if any issue happens, we're listening for it. We look out for them, but we also listen for our names as well. So the second we hear our name, and even before then, we anticipate when we start hearing echoes, let's fix this, let's work this out. And so it helps when issues do arise, they're resolved very quickly.
So Greg, from your experience, when you're sitting through these arbitrations and a party wants to have private communications either with their client or co-counsel during a break, how can you facilitate something like that?
There are a couple different things. So if they're participating in separate rooms, if the witness is in Canada, as we had, they can go into a breakout room, and Vince can go in a breakout room with his witness and communicate there. He can also share exhibits in that breakout room with the witness on a break. Share screen works the exact same way, but it's private there. Now, for other conversations, we recommend a text message or a group text to communicate if you're in separate locations, and setting that up beforehand. If you're in the same office and you want to have conversations, we do recommend leaving that counsel table room completely, leaving any room that has technology in it, even if you're muted and your cameras are off, just to be safe, to make sure somebody didn't forget to mute their microphone. The best place to have conversations with social distancing within your office is outside that room. One of the things we ask for as hosts is a master list of all participants that includes their name, email address, phone number, and their role, and so on and so forth. So by having to create that for us, you should have a direct line using that own list of yours, a direct line to everyone that you're working with. And we do recommend having that for quick messages. Generally, private chat is disabled on the Zoom platform to avoid coaching witnesses while on the record.
That makes sense. And speaking of coaching and other improper communication, I get this question a lot, prepping for depositions, trials, arbitrations, pretty much anything remotely. Jeff, how can you prevent witness coaching or improper communications from taking place during these remote proceedings?
Yeah, so in our arbitration, the chairperson admonished each witness that came on, do you have anyone in the room with you? Is there anything up on your computer screen? other than the Zoom platform? Where's your phone? Can you hold it up and show that you're not talking to anyone, and put it somewhere, so if we see you looking over there, we know where your phone is. And once that happened one or two times, everyone kind of knew the ground rules, and we didn't have any issues.
And then Vince, have you ever had any experience with that as well?
We actually had the exact same thing. It was the lead arbitrator, or chief arbitrator, asked the same questions Jeff just talked about. And I think, as you went, you got more and more comfortable that there wasn't any real-time coaching going on. Obviously, you prep with your witness. A good witness is a good witness. A bad witness is a bad witness. And those things show through. I thought they showed through in my arbitration, regardless of if there was any unforeseen coaching.
Earlier we briefly mentioned it, but I think it's worth revisiting the impact of technology just on our cognitive load, and how really can we decrease the impact in a virtual environment. I think, Anne, that's probably something best suited for you.
Yeah, sure. Well, I think I'm glad you brought that up again, because I don't think I really fully explained. I mean, that means that there are multiple things that people are doing, and the more things they're doing, the more overload they have. So when you add a remote situation into a normal a conversation or presentation or an arbitration, you're adding this other layer. Sometimes people are, like we all, watching yourself on the screen is another layer of, it takes away from the processing that you were able to do. And we tend to, for example, focus a lot more on peripheral cues, we would call them, or superficial cues. For example, about witnesses, when we can't focus on the detail. We can't focus because we don't have enough cognitive room, essentially. We're focusing on too many different things. So I think that's something that when you're in a remote situation, you really do have to concentrate a little bit more on, is making sure that things are simple. I would recommend, again, that we use graphics of some kind or visuals. I think you guys have talked a lot about exhibits. I'm sure some of them were visuals, graphics, diagrams, pictures, etc., which really are helpful to the arbitrators, because they'll draw their attention in, and then you can have the words on either side that you've honed into your theme. So I mean, it's just very important to keep a focus on, or to help them to focus, I should say, because they've got all those things, various things going on, plus the technology, plus the remote video that they're watching. So I think that clearly it's very, I've said it before and I'll say it again. I guess I'm beating this to death, but simplify, simplify, simplify. I think that's a key in these things, is keep it streamlined if you can, so that the arbitrators have a chance to absorb and digest all the important stuff you're saying.
I think it's also important to note that the cognitive load that we're talking about doesn't pertain specifically to within the walls of the proceeding. There's a lot of factors outside of these proceedings that are going to impact the participants, and all of that combined is really what we're talking about, impacting that cognitive load. And thank you, Anne. That's some really interesting thoughts to have, and that's something I would highly recommend, that if you have concerns with, speak with a consultant on those types of topics, because they're going to give you some insight as to how to minimize that impact on your witnesses and other participants of these proceedings. Now, I wanted to shift gears a little bit and give both Vince and Jeff a chance to talk about their firsthand experience in these remote arbitrations. We talked about the preparation, we talked about what to expect during it, but I'd be curious just to hear kind of broadly overall. We'll start with you here, Jeff. What was your overall experience taking part in a remote arbitration?
Yeah, for my takeaway, it was very positive. We had a great hearing. All of the evidence came in as well as we could have hoped, and to me, it was a real benefit. I think, as Vince said earlier, being in your own office just adds a layer of comfort. You don't have to. We had some staff available to help that wouldn't have been at the hearing if it were somewhere off site. Being able to, during breaks, go to your own office and access things in your network. So I think it was great. And the other thing is, as with any trials, you get closer to trial, you always kind of go through an exercise of whittling the case down to what really matters. And I think that's doubly true for a remote hearing. We trimmed all the fat. We're able to really sharpen our themes. and present our case exactly how we wanted.
How about yourself,
Yeah,
Vince?
I think I have to reiterate what Jeff said. I think the home field advantage was the biggest thing for me. It really took a lot of the stress out of the proceeding. Going to the courtroom every day, doing dealing with the exhibits that are there. When curveballs came, that's really stressful, as anyone knows who tries cases. Or being in Jan's office or AAA's office or wherever your arbitration proceeding is. Being in my office, having access to secretary, staff, printers, my own IT people, that took a lot of the stress, unneeded stress of the proceeding, and we could focus a lot more on the substantive issues and the prep of our witnesses and presenting evidence to the arbitrators. I really think it went really well. Particularly, it was about 3 months of my life that it took up. So it was, I thought it went really well.
And I've got to ask, just because, to be fair, of course, it sounds like things went great, but now knowing what you know and your experience you had in these remote arbitrations, is there anything that was on the contrary, things that you might consider changing your approach in the next time you would participate in a remote arbitration?
As Greg mentioned before, I'd probably get rid of that second monitor and just go with a simple laptop. That's a personal preference, but I think he's probably right in that regard. That we toyed with the whole using our big TV screen and using the the telecom system in our conference room. And I'm glad we didn't do that. But even the second monitor, I found it a bit distracting, and I probably would have been better off just going with the simple laptop from the start.
In hindsight, it's always easy to go, oh, what would I do differently? I think, just for me, the work with the text on the exhibits, that was super helpful. And I think going in, this going in the next one, having earlier relationship with that tech before you before you actually start the arbitration, and that's probably the one thing I would change, but that's really just a personal preference.
I think those are great points. And I know we're closing in on the end of time, and I've seen quite a few questions come in, and unfortunately we're not going to be able to get to a Q&A here. We're going to do our best to answer all the questions that have come through and send you out some responses to those who are participating in the chat window. But one thing I'd like to do is give everyone just one last opportunity, kind of that 60,000 foot for all of our listeners. If you could give one final piece of takeaway to those in attendance, I'll kind of run through everybody. Greg, what would be the kind of, in summary, what you would want somebody to know about the remote arbitration process?
That it goes extremely smoothly if you test. Testing is the key. Testing with every participant, small witnesses, your biggest witness, the arbitrators, and all attorneys, the paralegals, anybody participating, test with them. And we're happy to do that as many times as each person needs to make sure we work out all those issues.
How about yourself, Ann?
Well, I'm on a slightly different tack, because I think what Greg brings up and what the rest of you mentioned is the fact that this whole technology aspect, the remote aspect, does bring in the need for special skills like Greg's or a team or the lawyers who are experienced with it. But keep remembering that the same basic things apply in terms of persuading the arbitrator, and that arbitrators aren't all that different from, in that sense, judges that you're in front of all the time, or even jurors, because they really need to hear the story, and they really need to hear a compelling story. And so you have to keep your focus. Don't let the technology, let Greg be the background so that the technology doesn't take over your life, and you can focus on getting your messages and your themes out to your finder of fact, essentially, to your arbitrator, so you don't get lost in worrying about all the other stuff. That's why you need the other assistants to do this.
Great point. Jeff, how about yourself?
Yeah, my final statement would just be to say that I'm a big fan of remote hearings. I intend to do them again, even after things open up in certain circumstances. I think it really reduces costs to the client. There's way less travel, hotels, flights, things like that. I think it's good for the attorneys for all the reasons we talked about. I think being in your own office and you know, not having to travel. I think it's good for everyone. And I really, you know, I don't think the technology is very daunting. And I think it really is, at the end of the day, it's just a hearing, and you're doing the same things you would do in an in-person hearing. And to me, you know, there's some benefits, and I'm a big fan.
And Vince, finally, I'd love to hear yours.
Right. I just reiterating what Jeff and Ann just said. I think don't be afraid to do the virtual proceeding because you think there might be some disadvantage or advantage. It's all in the preparation, like any hearing. If you're prepared and you've done the groundwork going into the hearing, you're going to be fine. The facts are what the facts are, and that's not going to change because it's virtual. So I definitely will be doing virtual arbitrations or any proceedings that virtually, even after COVID. I do think, as Jeff said, it's a big savings to the client, and I think it's more efficient. And you can handle more things.
And I'll leave it with the final comment saying, make sure you lean on your vendor. That's the one thing I would definitely say. Put the burden of training and understanding the platforms, put it on your vendor, work with them closely. I can't stress that enough. The more fluid of a relationship you have with your vendor, the easier your interactions will be. That's just really something that I want to make sure that everyone takes away. And don't be scared to reach out to a vendor for what you might consider silly questions. If you've never participated in a remote setting before, every question is valid. Don't think there's anything that's off the table that shouldn't be discussed. Again, I know we're at the end of our time here, so I just quickly want to say thank you to all those who attended us today. Hopefully you found this presentation useful. Thank you to all of our panelists, to Greg, Vince, Ann, and Jeff. This was really helpful, and I really appreciate all of your time. We look forward to speaking with you all soon again. And if anybody listening has any further questions, feel free to reach out to your U.S. Legal Support contact, and they will be happy to set up any kind of communication with you further. Take care, stay healthy, and everyone have a nice day.